All right. Good evening, everybody. Thank you so much for taking time to join this webinar. My name is Samuel Bergsohn. I'm an associate attorney with Jacobowitz and Gubits. We're a firm in Walden, New York, in the Hudson Valley. This webinar today is covering landlord tenant proceedings in New York State and the impact of COVID-19. So it's definitely a pressing topic. It's definitely a topic that's impacting a lot of landlords and a lot of tenants in New York at this time. There's a lot of confusion, a lot of different laws. And so I'm hopeful that this webinar will be able to provide, some direction and some insight to landlords and tenants out there that are facing, legal situations. And so I'm an associate attorney. I work at Jacobowitz and Gubits. We are a full service law firm. We operate in Walden and Monticello, where we have offices. We've been serving the community for over 50 years. We have 20 attorneys, full support staff. We operate in over 30 areas of law, including bankruptcy, business, estate planning, environmental, equine, land use, litigation, real estate, real property tax, municipal law, personal injury, and pretty much every field of law that you can imagine. So if you are in the Hudson Valley and you have a legal issue, it does not have to be just a real estate or a landlord tenant issue. If you have any legal issues in the Hudson Valley, please reach out to our firm. We are exceptional and we can, definitely handle any legal issues that you might have. We do meetings in the office in person by appointment. We are absolutely fully capable to do virtual meetings via Skype, Zoom, Microsoft Teams, FaceTime, whatever would be easiest for you. So again, give us a call, reach out if you have any legal issues. I personally practice and concentrate in the field of municipal law, land use, real estate, and landlord tenant. So those are the areas of law that I personally practice in. Now, the topic today, we're focusing on evictions in New York, landlord tenant proceedings. And so evictions in New York, they're summary proceedings. A summary proceeding is the process through which a landlord may evict a tenant in New York State. These are justice court proceedings. They take place before a local judge in a town or a village court. So this is going to be like your small court. It's in your town, small courtroom. It's going to be an intimate setting. It's not going to be the county courthouse. These cases, these actions, they take place in the local justice court. Now, summary proceedings, being a statutory creation and not a common law right, must comply precisely with the statutory requirements. Otherwise, a dismissal of the proceeding on jurisdictional grounds might result. So what that quote is really saying is that if you, as a landlord, are initiating an eviction proceeding, you need to follow all the rules. If you make a mistake with some notice provision or you miss one of the rules, the judge is going to be forced to dismiss the case. So you have to follow all the rules if you plan on bringing an eviction action. And so evictions in New York are extremely complex processes. Landlords must navigate an increasingly complex web of rules and regulations surrounding landlord tenant proceedings in New York. Otherwise, like I just said, the case will get dismissed. And so not only do you have to follow the rules precisely, but the rules are extremely complex and extremely confusing, and that's what I'm here for. So if you're a landlord or a tenant and you have any questions about the rules, reach out. I'm more than able to assist. And as an aside, just so everyone knows, everyone that's viewing this webinar now is entitled to a free 15-minute consultation. So just please, if you have any issues, you're entitled to a free consultation. Don't hesitate. Reach out. I'll provide more information at the end how you can get that consultation. So again, evictions in New York are very complicated. The landlord-tenant relationship and evictions generally in New York are governed by Real Property Law, Article 7, and Real Property Actions and Proceedings Law, Article 7. And so that's where you'll find the rules. And so the question is, how does someone who's entitled to possession of the property bring a summary proceeding? So the first question is, what individuals are entitled to bring a summary proceeding? The answer to that is landlords, of course, are entitled to bring an eviction, a summary proceeding, eviction action. A purchaser at a foreclosure sale, they can also bring the summary proceeding to remove a tenant or a holdover. A lessee who's entitled to possession, and then any other persons lawfully entitled to possession of the premises can bring a summary proceeding to remove a tenant or someone who's in the property. At a minimum, the following papers will be needed to be served by the landlord on the tenant and then filed with the court. The first thing you're going to need is a preliminary notice. That's going to be a notice of termination or a notice of non-payment. The notice of termination applies for holdover actions. The notice of non-payment applies for non-payment actions. I'm going to get into those more in depth later on in the webinar. But just for now, you should know that a preliminary notice is going to be needed if you want to initiate any of these actions. You're also going to need a notice of petition and a petition. Those are essentially what gets filed with the court that sets the court date for the initial hearing. The notice of the petition, that will tell the tenant when to be in court, what time, and the location of the court. The petition itself will outline the complaint that the landlord is bringing and justify why the landlord is entitled to possession and why they can bring this action. So those are the three documents that are going to be needed to be filed by a landlord. The grounds for an eviction. So who can be evicted? A tenant can be evicted. What's a tenant? A tenant will include an occupant of one or more rooms in a rooming house or a resident, not including a transient occupant of one or more rooms in a hotel who has been in possession for 30 consecutive days or longer. No tenant or lawful occupant of a dwelling or housing accommodation shall be removed from possession except in a special proceeding. So the main thing to focus on is that 30 days creates a tenant. So if someone stays in the property for 30 days, they gain the rights as a tenant. Whether or not they have a lease, whether or not you've given them permission, if they've been residing in the property for 30 days by New York state law, that individual is now a tenant, and to remove them, you would have to bring a summary proceeding. And so we're gonna, like I said, we're gonna discuss the following summary proceedings in depth: non-payment proceedings, holdover proceedings, and then there are also situations where if you haven't hit that 30-day threshold, there might not be a tenancy, landlord-tenant relationship, and so there might be different situation to remove those individuals, and that's squatters. And like I said, I'll get into that a little bit more later on. Right now, I am going to address, I think, what's been a focus for a lot of landlords and tenants out there over the past 6-7 months, and that's the impact of COVID-19 on landlord tenant proceedings in New York State. And so on March 15th, 2020, the Unified Court System for the state of New York issued a memorandum. They stated that effective Monday, March 16th, all eviction proceedings and pending eviction orders shall be suspended statewide until further notice. On August 12th, 2020, the Unified Court System provided an update to that March memo. That update advised that any eviction matters commenced before March 17th, 2020 may resume with certain caveats. Residential eviction matters must be conferenced before a judge before they can proceed. No evictions may take place prior to October 1st. And respondent tenants may be eligible for an extension of time to answer. And then any evictions that were not commenced prior to March 17th remain suspended. So what's going on? That means if you have filed a notice of petition and a petition before March 17th, then your case can resume with the caveat that the tenant's not going to be able to be removed before October 1st, which date is coming quickly. And also, the eviction hearing must be conferenced before the judge. And so I've had to go back to court on a case that essentially was closed out. I had a judgment of possession. I represented the landlord, and I had a judgment of possession. I just needed the judge to sign a warrant of eviction. He had disposed of the case. We had won the case, but because of the memo from the unified court system, the judge had to call us back and conference us back, and we had to go back to court. I'm still waiting for that eviction warrant to be executed by the judge. So even though some of the cases that were initiated before March 17th, they now can resume, they're not really moving on a fast track pace. Certain judges might not even be entertaining actions in landlord tenant matters. And so you need to really reach out to your justice court if you're in that situation, and to see how they're going to handle a case that might have been filed prior to March 17th. If the case, if you haven't filed a notice of petition or a petition, or if you're a tenant and a notice of petition or a petition hasn't been filed against you at this time, then that landlord is still prevented from doing that until further notice from the Office of Court Administration. So for the most part, evictions are not going forward until we get further notice from the Office of Court Administration. Now, there were also several executive orders that were passed. And early on, before, there was multiple memos from the Office of Court Administration, the executive orders were having an impact. They did impact landlord tenant proceedings. At this point, I would advise that you should take your cues from the Office of Court Administration. They're going to be the ones who say when residential evictions can proceed, when the courts can open up. And so I wouldn't look for an executive order to give that green light. I would look for a memo from the Office of Court Administration. I'm not sure exactly when that's going to happen, but hopefully we will get more direction soon. So just very quickly to look at the executive orders that were passed. On March 20th, Governor Cuomo issued Executive Order 202.8, which stated that no eviction proceedings or eviction warrants would go forward through June 20th. Now, those protections have continually been extended. They've been extended now through October 4th. And so, like I said, I would say the Office of Court Administration, they're going to be the ones who provide a memorandum that says when landlord tenant matters can resume in justice court. But the executive orders do add another layer of protection. And so right now, those executive orders are providing protection through at least October 4th to tenants in New York State. And just very quickly, as an aside, Executive Order 202.64, which passed, I think it was last week, extended protections for commercial tenants facing evictions for non-payments through at least October 20th. So, say the landlord initiated an action before March 17th and you were facing a potential eviction, the protections for commercial tenants facing eviction for non-payment were extended through October 20th. And so those were the executive orders that came down from Albany. Now, another issue is that the CDC issued their own moratorium on evictions a couple of weeks ago. And so the CDC, we all know they're a federal agency, and the CDC issued a nationwide moratorium on evictions through December 31st, 2020. This covers non-payments. It does not cover holdovers or breaches of a lease. The order provides a defense for covered persons in landlord tenant proceedings. Covered persons are specifically defined by the CDC order. And so I'd advise you to look up the CDC order. And covered persons make less than $99,000 a year. They're making attempts to make partial payments. They have financial difficulties. There are several caveats that categorize a covered person, that define a covered person. And so you would have to be a covered person to apply for the defense that is being provided by the CDC order. And so what happens here is this CDC order, it's not going to stop a landlord tenant proceeding from going forward. It's not going to stop that action from getting initiated. But what happens here is it's on the tenant to raise the CDC order as a defense. And if the tenant is able to do that, they need to get a declaration. It's included with the order, so you can look on the CDC website to get a copy of the declaration. It has to be executed and signed under penalty of perjury by the tenant that they are a covered person, that they have been attempting to make payments, that they are making less than $99,000 a year, et cetera, et cetera. And if you apply and submit that declaration, then the judge will adjourn the matter through December 30th, 2020. So again, there is a CDC order that provides another layer of a defense for tenants out there who are facing a non-payment situation, a non-payment eviction, whether it's a residential or commercial eviction. This moratorium, you know what? I believe it's only for residential evictions. This moratorium, this will apply so long as the tenant submits to the court a declaration stating that they are a covered person. And so far we have the Office of Court Administration in New York, who has provided memorandums dictating when evictions may resume. There are executive orders that provide another layer of protection to tenants in terms of when an eviction can go forward. And then there's also now the CDC moratorium that's been passed down from the federal agency that provides even more protection to tenants. So there's really a lot going on. Like I said, at any point, if you're a landlord or a tenant and you're confused about these items, you need more clarification, give me a buzz. You're entitled to a free 15-minute consultation, everybody that's viewing this webinar. And so moving on, I do want to quickly cover that in New York, one of the executive orders provided that tenants facing hardship may elect to have any security deposit held by a landlord applied toward overdue rental payments. If they do that, the following conditions apply. The agreement must be in writing. The tenant must replenish the deposit at a rate of 1/12 the amount used per month. The agreement must cover the entire amount due, otherwise the remaining amount is waived. And the repayment shall not become due until 90 days after the security deposit is used for rent. And so this is another, option that the governor's office provided where, a tenant does get an extra relief if they're, choose to apply the security deposit to rent. They need to replenish it. If they don't do that, then it will create, an action where the landlord can go after the tenant for that money if it hasn't been replenished. But in theory, that will give, and it has given tenants an opportunity to make a monthly payment that they might not have otherwise been able to make. And so just kind of to close out a few slides that I'm addressing the impact that COVID-19 has had on landlord tenant proceedings and relationships really in New York since March. Just some advice. I deal with landlords and tenants every day. I speak with landlords, I speak with tenants every single day. And some advice, the main point of advice is that I would say to talk to each other. Tenants who have been impacted by a hardship, they need to let their landlords know that. If their landlord doesn't know that, then they might not be getting the full benefit of some of the current legislation that's been passed down by the state and at the federal level. And then landlords, they should also reach out to their tenants to inquire about their situation. It's always better as a landlord to try and have a full understanding of what your tenant is dealing with. personally, financially, in any sense. So that being said, nothing is currently preventing landlords from sending out required notices and having papers prepared for filing once the courts resume landlord tenant proceedings. So send out preliminary notices. You know, if you have a non-payment case or you have a holdover and the lease is expired, send out the notice. There's no reason why you should wait to send out a notice to begin this action. I mean, you know, you can potentially, if you're a landlord, you can potentially affect your tenant. Maybe they get a notice and maybe they decide that it's better to leave. And at the same time, if the courts do reopen, you have that jump start. You've sent out a notice, you've gotten everything started. So landlords, send out preliminary notices. Tenants, you need to be aware, and I'm sure at this point it's been, I'm sure after several months you're aware that because you can't get evicted does not mean that you don't owe your rental payments for the previous 6 months. If you just, the fact that the courts haven't been open doesn't mean that you didn't sign a contract. As a tenant, if you signed a contract, then you owe that monthly payment and it's going to become due and owed, and the landlord is still entitled to that money. And so you should, like I said, try and see how you can work out an arrangement to, make that payment if there's any way that you can do so. And so tenants need to be aware that none of these monies that are owed to their landlord is forgiven. You still owe your landlord. And so now I'm gonna move on. I'm gonna move out of the COVID realm. I'm gonna move into the general realm of landlord tenant proceedings in New York, and I'm gonna, give a quick overview, like I said, of non-payment proceedings, of holdover proceedings, of some other proceedings that some, where an eviction might be necessary, and I'm gonna essentially give you an idea of what the landscape is in New York. And so the first type of eviction matter that a landlord could bring against a tenant is, of course, a non-payment proceeding. Now, a non-payment proceeding, that might be initiated by a landlord against a tenant who does not pay the agreed upon rent. And so you're going to actually require 2 notices here. The 2 preliminary notices are required. First, if within 5 days after the payment is due, a landlord has not received the rental payment, they need to send a notice to that tenant advising the tenant that the payment hasn't been received. That is a necessary notice. It's a 5-day notice that they have not received that rental payment. Once that notice has been sent, then the next preliminary notice that's required and it's necessary in these situations by the landlord is the 14-day notice to cure non-payment notice. And so that 14-day notice essentially gives the tenant 14 days to remit the entirety of the funds owed. Otherwise, the case will proceed. And so in these situations, the tenant in a non-payment proceeding, they can cure their default, they can cure the payment that's owed at any time in the proceeding up until the point that they are evicted. And so the landlord might go through the process, file an action, take the tenant to court, get a favorable judgment, get a warrant of eviction, and then the day before that tenant leaves, if the tenant pays in full the landlord, the landlord can't do anything about it. That tenant can stay until the end of their lease. And so that's very important that in any non-payment proceeding, the tenant is able to cure that deficiency at any point up until they are evicted. Now, holdover proceedings. Holdover proceedings are just like the title explained. It's when a tenant holds over, remains in the premises after the expiration of the term of the lease. So, the lease has a certain set term. That tenant holds over, remains in the property. They can be evicted now, as long as you, as a landlord, provide the proper notice. And so the holdover proceedings are summary proceedings that may be initiated by a landlord against a tenant who remains in possession of the premises after the expiration of the lease term. A holdover action is going to require either a 30, 60, or a 90-day notice, depending on the length of the term. If the tenant has been in the premises for less than 1 year, or the lease is less than 1 year, whichever is the greater time period holds. But if they've been in the property for less than 1 year, a 30-day notice is required. If that tenant has been in the property between 1 and 2 years, a 60-day notice will be required. And if the tenant has been in the property for over 2 years, a 90-day notice will be required before a landlord can initiate a holdover eviction proceeding. Once that 30, 60, or 90-day notice is sent, no other notices are needed. You can submit your notice of petition and petition, have it served on the tenant, and initiate your action. So it's very important to make sure that the proper notice is sent. If a 90-day notice is required and the landlord only sends a 30-day notice, the judge has to dismiss the case. I'll take you back to that first slide where I told you the rules are very important. And if you don't follow the rules, the case is going to get dismissed. No matter how unfair that might be, the judge has to dismiss the case if you don't follow the statutory guidelines. And so another specific guideline for a holdover action is that you need to file the notice of petition between 10 and 17 days before a court appearance. And so this means that the petition, which is the complaint essentially, that's going to need to be filed with the court within 10 and 17 days before a court appearance. And so say you have a court appearance on the 17th of a month, you're going to have to file your paperwork between the 1st and the 7th, because that's between the 10th and 17th days before that court appearance. I know it's complicated. That's why if you are a landlord and you have a holdover situation, you need to make sure you send out a proper notice. You need to make sure it's filed properly. Now, another thing too, these holdover notices, they need to get served by a process server. And so, if these are all situations that are pitfalls landlords could potentially fall through when they initiate an action. And then at the same time, these are all issues that tenants can easily take advantage of. If they recognize that a landlord might not have sent the proper notice, then absolutely they should go into court and raise that defense, and they'd be entitled to remain in the premises until the landlord properly follows the rules. And so, again, I'll just repeat that everyone who's watching the webinar, you're all entitled to a 15-minute consultation. And so, if you have more questions about holdover proceedings, non-payment proceedings, anything really, don't hesitate. Reach out, give me a buzz, and I can address your specific issues. And so grounds for eviction where no landlord-tenant relationship exists. I had briefly mentioned this. This only requires a 10-day notice to quit before you bring a summary proceeding. Typically, that would be a squatter situation. So, if a squatter, someone illegally enters a property, remains there, then you still need to go through a process to get them removed. You can try and call the police, but if the police aren't going to remove them and they say it's a court matter, it's a landlord-tenant matter, then you're going to have to go through this process. And a 10-day notice to quit would be effective against squatters, but if they remained in the property for more than 30 days, they would actually gain the rights of a tenant, and you would have to go through a holdover or another proceeding to get that, a holdover proceeding to really get them out. And so, typically this happens a lot. Holdovers post a foreclosure sale, with squatters, like I said, and with the licensee, someone who's allowed to operate on a property and their license might have expired. Those are the most typical situations where a 10-day notice to quit would be appropriate. But in general, these actions are not very common. It's just not a common situation, but a 10-day notice. And so next I'm going to just quickly address how would a tenant respond to a summary proceeding brought against them. And so say, you're a renter, your landlord brings an action, holdover, non-payment, lease violation, which is essentially the same thing as a holdover. What does the tenant need to file? The tenant really doesn't need to file anything. The tenant is not going to be required to file a paper answer. Typically, that is the case, in normal court cases in Supreme Court and county court, a written answer is required. In this case, it's not. The petition and the notice of petition from the landlord will set a hearing date. And as long as the tenant appears at that initial hearing date, they will be allowed to raise a defense. And so the tenant does not need to file a written response. They can appear on the court date and they can raise any defenses that they have at that time. Now, the most common successful defenses to any eviction proceedings are, well, first, for a non-payment, I paid you. If the tenant makes a payment and they pay and they get themselves up to date on the payments, it doesn't matter at any stage of where that eviction is. If it's initiated as a non-payment proceeding, that tenant will get that case dismissed. So, the tenant can make that payment. Say the tenant still has 4 months left on the lease. They make a payment. They dismiss the action. The tenant can remain in the property as long as they, continue making payments through the end of the lease. If they fail to make another payment, that landlord will have to reinitiate and start a whole new action all over again. If the landlord also failed to follow notice requirements in bringing either a non-payment or a holdover proceeding, they missed the 30, 60, 90 days, they didn't send a proper 14-day notice, they didn't file it within 10 to 17 days. There are numerous other notice requirements that landlords need to follow. And so, another defense would be that the landlord might not have followed that notice requirement exactly as the statute requires. If that's the case will need to get dismissed. As frustrating as it is for landlords, I've said it repeatedly, these cases require strict following of the rules. And if you don't follow the rules, the judge has to dismiss. A last defense is that maybe the landlord breached the warrant of habitability. What this would mean is that the landlord might have allowed a condition to arise in the property, or maybe not fixed the condition in the property that affected the basic rights of the tenant in terms of maybe water, keeping the property heated, providing electric. If the landlord might have cut off one of those things or created a situation that otherwise makes the property unlivable, that could potentially absolutely rise as a defense for the tenant. It might be more of a fact-based defense that the judge, the court might have to make a decision on, but that could rise to a defense. And so those are the most common defenses. And then, I'm getting toward the end here. I've gone through the impact that COVID-19 has had on landlord tenant proceedings in New York State. I've gone over the basics of holdovers and non-payment proceedings in New York, the notice requirements, but I think it's very important, and I want to address some recent changes in the law. As of July of 2019, New York State actually passed an update to their landlord tenant laws, and that was called the Housing Stability and Tenant Protection Act of 2019. And I just want to quickly go over some of the most relevant provisions from that new law. First, a 14-day adjournment is required if it's requested by the tenant at the initial hearing. And so, you're a landlord. Say you serve all your documents. You serve your notice of petition and petition, your preliminary notice. You get a court date. You show up to court. The tenant in that situation, by law, is allowed to come to court, ask for an adjournment, and the court has to grant that adjournment. It has to grant at least one adjournment to the tenant. No matter what the situation is. If the tenant comes in and says, Your Honor, I'm requesting an adjournment, the judge is going to give it to the tenant. Next, only fees for use and occupancy will be allowed to be demanded in a summary proceeding. Other fees now require separate actions to recover a judgment against those tenants. And so what we're talking about really here is, can you bring an action for more than the rent owed? Can you also ask for late fees? Can you also ask for damages? The answer is no. In the summary proceeding, whether it's non-payment or holdover, that proceeding, you can only ask for the rent, for the use and occupancy, the monthly amount that was owed by the tenant for rent. Any other additional fees laid out by the lease, whether they're late fees, attorney's fees, damages, all of those items, you will need to bring in a separate plenary action. It's going to have to be brought in a separate action, whether that's in small claims court or county court. Next, I just want to mention that new rule that warrants of evictions may not be served for at least 14 days after the order of possession is entered. So, if you get a decision from the court and they say they order the sheriff to execute a warrant of eviction, the sheriff has to wait 14 days before they can go ahead and do that. So again, it's another period of time that the tenant gets to remain in the property, even after they've lost the case, even after the warrant of eviction has been ordered, the tenant's still going to get at least 14 more days before the sheriff comes and physically removes them. And then lastly, the court is going to have, they have a new discretion to issue a 1-year stay of the warrant of eviction. And so say the tenant in court is asserting some, legitimate hardship, and the court wants to give that tenant more time in the property, more time to find a new place to live, more time to get settled, the court within its discretion, and I've never seen this in my, since July of 2019, the court in their own discretion can stay a warrant of eviction for up to 1 year. I've never seen them do it at all. It doesn't happen right away that these warrants get executed often. And so I haven't seen it, but the judges are entitled to do that. And so those are the most important aspects of the Housing Stability and Tenant Protection Act of 2019 that impacted landlord-tenant laws in New York State. And it's very important. I want to make this point very clear. Anyone who's, if you're still following along with the webinar, there are a lot of resources online on landlord-tenant issues in New York. A lot of those resources were published online before July of 2019. And so you might see online some information that says a non-payment notice only needs to be a 3-day notice. That's because it was before the 2019 act was passed. And so in 2019, they changed it from a 3-day notice to a 14-day notice, like I said, for non-payments. And so you might see things that are dated. And I just want to caution you, if you look online for information about landlord-tenant proceedings, just be cautious that what you find might not be accurate. And again, I would advise you, if you have a question, to be absolutely sure and to get the right answer, reach out to me and I can, give you some advisement. I can handle your case. I'd be more than happy to, assist and give you the accurate information. And so that's really it. Like I said, I covered the impact that coronavirus, the COVID-19 pandemic has had, and it continues to have on landlord-tenant proceedings in New York State. I've covered the basics of holdovers and non-payment proceedings in New York State. I've covered the new changes in the law as of July 2019 that landlords and tenants need to be aware of. And I covered all the rules and requirements, the notice requirements, and the strict nature of all those rules for landlord-tenant proceedings. And so, like I said, if there are any other questions you have, don't hesitate to reach out. You're entitled to a 15-minute consultation. You have my contact information below. Please reach out to the firm. If you have any issues that are not landlord-tenant related, please reach out to the firm. We'd be more than happy to discuss and address your issues. At this point, the courts, we do hope they're going to open up soon. And so as they, as we prepare for the courts to open up, we anticipate a high volume of landlord-tenant issues. So, don't hesitate. Don't think that, the courts aren't going to open. I don't want to, reach out. If you have an issue with the tenant or a landlord, get in front of it. let me know. And, I really hope that this webinar has been informative for everybody. I'm going to spend a couple of minutes. I see there have been a couple of questions. People can feel free to continue to submit a couple of questions here. And I'll just sit here on this page. So let me see what we got. I got, do I need to send a request for rent to a tenant who holds over? I got one question there. No, you don't. You do not. What you can do is you're going to send a holdover notice. When you bring your action, you can request the rent when you bring that action. You can request only the rent, but you're entitled to request rent when you bring a holdover action. Let's see. How can I get a copy of the notice of petition and petition forms? Can those be filed in New York City courts now? No, they can't. If it was an eviction that started, if the papers haven't been filed yet, you can't. Not yet. How can you get the notice of petition and petition forms? I would say you would need to engage with an attorney. That's something that I would draft a notice of petition and petition forms. You can look online. I'm looking, I don't see any other questions. I don't have any Q&As. So there's one that just popped up. Let's see, to serve the notices, can they be served by certified mail, in hand, or something else? Okay, so the holdover notices, the 30, 60, 90-day notices, that needs to be served by a process server, personal service. That's often an issue because a lot of times people call me, they say, I sent out the termination notice, but it wasn't served by a process server. And so that'll need to get served by a process server. Everything else, like a non-payment notice, the 5-day notice, those can be served certified mail. But I'd reach out to me, if you have a particular situation. So that's it. Let me see. I mean, I don't see any other questions. I'm going to sit tight for another 1 minute. If anyone wants to, submit a question, I'll give you another minute till 6:45. But again, I really, really, really appreciate everyone. Thank you so much. I hope this was informative. There's, changes will be coming down the pike soon. I got one more question. Let's see. What's the situation with taking possession after a foreclosure? So that's taking possession after a foreclosure. It's not a tenancy. You could send a 10-day notice. I'd send a 30-day because you're not going to get into court. The courts aren't open. If it's a post-foreclosure eviction, it's still an eviction. So you're still waiting for the green light from the Office of Court Administration. But typically you would only need to send a 10-day notice, but I think you should just send a 30-day in this case to that whoever's, holding over in that case. I see one more. If you're a landlord and have a tenant who has been paying month to month without a lease, does a holdover pertain? It does. Yes, it does. That is a holdover situation. They don't have a lease. You're allowed to notice them and evict them at any time, but you have to send the proper notice. If they've been in the property for 1 year or less, 30 days. 1 to 2 years, 60 days. Over 2 years, 90 days. All right. So that's it. I appreciate everybody very much. Thank you so much again. Reach out to the firm if you have any more questions. I hope you all have a wonderful, wonderful day. How long for foreclosures when they have lived there for a long time? You're going to have to send Alex, reach out to me. You get a free 15-minute consult. Give me a buzz and I can answer that question for you. Call me tomorrow. Everybody else, have a wonderful day. I wish you all the best. Stay safe. Keep social distancing. Please wear masks, everybody. And we will probably be having another webinar sometime in the future. Also, look out for other webinars from the firm. And I hope everyone has a great night. So thank you so much. Be well, and good night.